Sexual harassment is illegal in California and not tolerated in any workplace. It's estimated that 50% of women and 20% of men have experienced sexual harassment at work. Sexual harassment can inflict serious damage on an organization's productivity and morale. And individuals named in sexual harassment complaints could lose their jobs, their reputations, and even their careers. Additionally, employees may be found personally liable in court for acts of harassment. In California, sexual harassment is defined by both the Fair Employment and Housing Act and Title VII of the Federal Civil Rights Act of 1964. Federal law defines sexual harassment as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. The Fair Employment and Housing Act, FEHA, defines sexual harassment as harassment based on sex or of a sexual nature, gender harassment, and harassment based on pregnancy, childbirth, or related medical conditions. There are two types of sexual harassment: quid pro quo and hostile environment. Quid pro quo sexual harassment occurs when a manager or supervisor withholds or awards job benefits on the basis of sexual favors. This includes work assignments, hiring, termination, promotions or demotions, positive or negative performance reviews, or any other job-related benefit. Quid pro quo sexual harassment is a serious offense, and just one instance is usually sufficient for a plaintiff to win a lawsuit. In California, managers and employers can be held liable even if a threat was not carried out, or if a threat was only implied. For instance, a manager who suddenly blocks a subordinate employee's promotion after that employee asks the manager to stop rubbing her shoulders could be found guilty of quid pro quo sexual harassment, even though there was no verbal threat of adverse employment action. Additionally, California courts have ruled that managers and their employers cannot require employees to tolerate unwelcome sexual advances as a condition of employment. For instance, a supervisor in a restaurant could be found guilty of quid pro quo harassment if he tells his employees that they should put up with lewd comments and inappropriate touching because it's part of the job of being a waitress. Hostile environment harassment occurs when the conduct unreasonably interferes with an individual's work performance or creates an intimidating, hostile, or offensive working environment. Federal courts have adopted the reasonable person standard when addressing sexual harassment. In other words, would a reasonable person find the behavior offensive? The fact is that most behaviors that are continuous and unwanted and based on sex meet this standard. The safe way to avoid sexual harassment is to avoid these behaviors entirely. Hostile environment sexual harassment can occur between employees of the same sex, between employees of different sexes, and between employees of any rank or position in the organization. Harassing jokes, comments, or other behavior can create a hostile work environment even if they aren't directly targeted at the individual making the harassment complaint. For example, a transgender employee who was forced to endure jokes and hostile comments by coworkers, even if the comments were not directed at the employee personally, may have the legal basis to file a harassment complaint. Sexual harassment is often perpetrated between coworkers, but it also occurs between employees and individuals not directly employed by an organization. Individuals such as contractors, consultants, delivery persons, vendors, and even customers. Sexual harassment can occur anywhere that employees represent their organization. This includes work parties, dinner with clients, conferences, trade shows, sales calls, and charity events. Sexual harassment can be perpetrated in person, on the phone, through text messages, instant messages, emails, or through social networking sites. The following inappropriate behaviors are specifically mentioned by the Fair Employment and Housing Act as forms of sexual harassment. Unwanted sexual advances like flirting, propositions, or repeated requests for dates. Actual or threatened retaliation for filing a sexual harassment complaint. Leering, making sexual gestures, or displaying sexually suggestive objects, pictures, cartoons, or posters. Making or using derogatory comments, epithets, slurs, or jokes. Sexual comments, including graphic comments about an individual's body. Using sexually degrading words to describe an individual, or sending suggestive or obscene letters, notes, or invitations. Unwanted touching, such as shoulder massages, hugging, and back scratching. Physically assaulting a coworker, or impeding or blocking an individual's movements or ability to work. Making derogatory comments about a person's sexual orientation, gender identity, or gender expression. Making inappropriate remarks or jokes about a woman's pregnancy, childbirth, or other related medical conditions. Other inappropriate behaviors that could lead to illegal harassment include gossiping or spreading rumors about sexual topics, or engaging in sexual conversations that are overheard by others. The use of demeaning or offensive names such as honey, sweetie, hottie, baby, girl, boy, or hunk. Offensive gender-based comments or behaviors that degrade people simply because of their gender, such as a woman's place is in the kitchen, not the boardroom. Under California law, employers must display a poster and distribute a brochure made by the Department of Fair Employment and Housing, or create an equivalent brochure of their own. Additionally, employees must be given a written harassment and retaliation policy immediately upon hire. The DFEH brochure and the written harassment and retaliation policy are separate documents, and one cannot replace the other. If 10% or more of an organization's employees speak a particular language other than English, the policy must be translated into that language. This harassment and retaliation policy must include a list of all current protected categories covered under the FEHA, indicate that managers, supervisors, coworkers, and third parties are prohibited from engaging in unlawful conduct, create a complaint process and procedure as defined by the DFEH. Employers in California must take all reasonable steps to prevent discrimination and harassment from occurring, and employees are encouraged to speak up if they feel they are being harassed or if they witness the harassment of a coworker. California regulations specifically warn employees not to use peer pressure to discourage victims from filing a complaint. Employees in California have the right to report harassment to someone other than their direct supervisor, and they must be allowed to submit harassment complaints orally or in writing. Additionally, employees have the right to report the sexual harassment to the DFEH within 1 year of the harassment incident and must be given the department's contact information. Complainants must have all their individual rights and their employer's obligations fully explained. Harassment complaints must be treated with confidentiality whenever possible. However, complete confidentiality cannot be guaranteed. Employees have the legal right to be free from retaliation for filing a harassment complaint, and employers must ensure that retaliation does not occur. Supervisors in California must report all complaints, without exception, to a designated company representative, such as an HR manager. Complaints must receive a quick response and a timely and impartial investigation by a qualified representative. A determination based on the investigation must also be made in a timely fashion and reported immediately to the complainant, the accused, witnesses, and all other parties directly concerned. If it's determined that illegal harassment occurred, then immediate action must be taken to stop the harassment, ensure that it does not reoccur, and ensure that no retaliation occurs because of the complaint. If disciplinary action is warranted, then it should be executed promptly using the organization's progressive discipline policy. In addition, periodic follow-up should be undertaken to watch for reoccurrences of the harassment and instances of retaliation. All actions taken to remediate the complaint must be communicated to the complainant. Lastly, appropriate action must be taken to remedy the complainant's damages. Appropriate remedies include policy changes by the employer, rehiring or reinstatement, back pay, promotions, and fines and damages for emotional distress. If complainants disagree with the findings of the investigation or with the actions taken to remediate the harassment, they have the right to lodge a complaint within 1 year of the harassment with the DFEH. All employees must be given contact information for the DFEH. The DFEH serves as a neutral party and seeks to resolve disputes. If evidence of harassment is found and settlement attempts fail, a lawsuit may be filed on behalf of the complainant. Complainants also have the right to pursue a private civil lawsuit in court once the complaint has been filed with the DFEH. Sexual harassment has consequences. Sexual harassment can result in disciplinary actions, including written warnings, suspension, demotion, and even termination. It's also illegal to retaliate for a sexual harassment complaint. This can also lead to disciplinary actions, up to and including termination. Additionally, perpetrators of sexual harassment can be found personally liable in court. What can you do to prevent sexual harassment? It's simple. Leave offensive behaviors at the door. Treat everyone with respect, and speak up when you witness harassment. If you feel that you have been harassed, report it. Every employee deserves a safe, comfortable environment at work, a workplace free of harassment and fear, and full of respect. It's up to everyone to do their part in preventing harassment. Harassment is illegal and not tolerated in any workplace. Harassment can inflict serious damage on an organization's productivity and morale. It causes absenteeism, employee turnover, depression, illness, embarrassment, and humiliation. And individuals named in harassment complaints could lose their jobs, their reputations, and even their careers. Workplace harassment occurs when people are treated poorly or unfairly because of a perceived difference. Court rulings have established protected groups that are afforded legal protection from workplace harassment. These groups are defined by race, color, and national origin; religion, either because of a person's faith or beliefs, or pressure to join or convert to a faith; disability, either mental or physical; family status, including marital status and pregnancy; gender; age for employees 40 and over; genetic information; and sexual orientation and gender identity. In addition, local laws and organizational policies prohibit the harassment of many other groups of employees. To put it simply, harassment of any type is unacceptable. There are two types of harassment: hostile environment and quid pro quo. Quid pro quo harassment occurs when a manager or supervisor withholds or awards job benefits on the basis of sexual favors. This includes work assignments, hiring, termination, promotions or demotions, positive or negative performance reviews, or any other job-related benefit. Enduring harassment as a condition of employment is another form of quid pro quo harassment. For instance, it's illegal for a warehouse manager to tell his employees that they will simply have to ignore culturally offensive comments from their coworkers because they are commonplace in blue-collar jobs. And it would also be unlawful for a restaurant supervisor to tell employees to put up with racial slurs from customers because it's part of the job of being a server. Just one incidence of quid pro quo harassment is illegal. Hostile environment harassment occurs when a pattern of offensive conduct unreasonably interferes with an individual's work performance or creates an intimidating, hostile, or offensive working environment. In most cases, harassment must be continuous and unwanted to rise to the level of illegal harassment. However, while a single, isolated incident does not generally rise to the level of illegal harassment, severely inappropriate behavior, such as the touching of an intimate body part, can be illegal the first time it occurs. Inappropriate conduct can create a hostile work environment even if it's not directly targeted at the person making the harassment complaint. Harassment doesn't just happen between coworkers. Harassment also occurs between employees and individuals not directly employed by their organization. Individuals such as contractors, consultants, delivery persons, vendors, and even customers. Harassment can occur anywhere that employees represent their organizations, This includes work parties, dinner with clients, conferences, trade shows, sales calls, and charity events. The courts use the reasonable person standard when determining if offensive conduct is illegal. In other words, would a reasonable person find the behavior severe enough to create a hostile work environment? The fact is that most offensive behaviors, when they are continuous and unwanted, meet this standard. The safe way to avoid harassment is to avoid these behaviors entirely. The following conduct is unacceptable in any workplace, and when targeted toward a protected group, could lead to illegal harassment: ridicule, mockery, insults, or put-downs; physical assaults or threats, intimidation, or physically blocking a person's movement or ability to work; the use of demeaning or offensive names, or the use of slurs or epithets; gossiping or spreading rumors about coworkers; jokes, banter, or remarks that are demeaning or degrading; menacing looks or gestures intended to threaten, intimidate, or humiliate a coworker; texting pictures, messages, or videos that offend, demean, or harass a coworker; sending offensive or harassing emails, viewing offensive websites, and using social networking sites for harassing or offensive behavior; sexual harassment, which includes any continuous unwanted behavior of a sexual nature, whether physical, visual, or verbal; disparaging comments about a person's job ability, such as, "He is too old to understand technology"; inappropriate remarks or jokes about pregnancy, childbirth, or medical conditions related to pregnancy or childbirth; offensive gender-based comments or behaviors that demean people simply because of their gender, such as, "A woman's place is in the kitchen, not the boardroom"; excluding or isolating coworkers from work-related activities and assignments because of a non-work-related reason, such as race, religion, gender, or sexual orientation. Incidents of quid pro quo harassment and severely inappropriate actions, such as the touching of an intimate body part, threats, or intimidation, must be reported immediately. For less serious conduct, it is helpful, but not required, to tell coworkers that their behavior is unwanted. However, employees should report incidents of inappropriate behavior before they become severe or pervasive. Although some information must be divulged in the process of investigating complaints, confidentiality is guaranteed to the greatest extent possible. It is illegal to retaliate against employees for making or participating in a harassment complaint. This means that managers and employers cannot punish or discipline employees for filing or participating in a harassment complaint. Likewise, non-management employees cannot bully, harass, intimidate, or threaten coworkers for participating in a harassment complaint. Even if the complaint is found to be without merit, the participants are protected if they had a good faith belief that harassment occurred. Harassment has consequences. Both harassment and retaliation can result in disciplinary actions, including written warnings, suspension, demotion, and termination. Harassment charges often affect future career advancement and may even hamper the ability to be hired by another organization. The loss of personal reputation and trust with coworkers, friends, and family can be devastating and life-altering. What can you do to prevent harassment? It's simple. Leave offensive behaviors at the door. Treat everyone with respect. And speak up when you see harassment. Every employee deserves a safe, comfortable environment at work, a workplace free of harassment and fear, and full of respect. It's up to everyone to do their part in preventing harassment. In addition to sexual harassment, the Fair Employment and Housing Act prohibits harassment and discrimination of certain protected groups. While the Act covers all federally protected groups, it also expands the list to include even more employees. California employees are protected from harassment and discrimination based on their membership in the following groups: race. Religion, which covers all aspects of religious belief, observance, and practice, including religious dress and grooming. Color. National origin. Ancestry. Physical disability. Mental disability. Medical condition. Genetic information. Marital status. Sex, which includes gender stereotypes, such as assumptions about appearance or behavior, or myths about a particular gender's ability or inability to perform certain tasks. Pregnancy, childbirth, or medical conditions related to pregnancy and breastfeeding. Gender. Gender identity, which is defined as a person's identification as male, female, or a gender different from the person's sex at birth. Gender expression, which is defined as a person's gender-related appearance or behavior, whether or not stereotypically associated with the person's sex at birth. Age, for employees 40 and over. Sexual orientation. And military and veteran status. In particular, managers and supervisors should take great care to not engage in harassment or discriminatory conduct that affects a tangible employment action, such as hiring, firing, demotion, or promotion. For example, a manager who has chosen not to promote a pregnant woman for no other reason than the fact that she is pregnant has committed illegal discrimination. Some other examples of behaviors that could result in illegal harassment under the Fair Employment and Housing Act are requiring employees to tolerate harassment as a condition of employment. For instance, a warehouse manager who tells his employees that they will simply have to ignore culturally offensive comments from their coworkers because they are commonplace in blue-collar jobs. Refusing to hire a prospective employee because of religious grooming habits. Retaliating against an employee for filing a harassment claim. Making employment decisions or comments based on stereotypes about members of a protected group. For example, a manager who refuses to hire older employees for technology jobs may be committing illegal harassment if his decisions are made solely on age. The use of demeaning or offensive names, or the use of slurs or epithets. Telling insensitive jokes that are demeaning or degrading to a particular race, culture, sex, or any other protected group. Excluding or isolating someone from work-related activities and assignments because of a non-work-related reason, like race, religion, gender, or sexual orientation. Texting pictures, messages, or videos that offend or harass a coworker. Sending offensive or harassing emails, viewing offensive websites, and using social networking sites for harassment or offensive behavior.
According to guidance from the EEOC, a valid retaliation claim must contain 3 elements. 1. An employee's participation in a complaint of discrimination or harassment. 2. An adverse action taken by the employer or manager against the employee. 3. A causal connection between the protected activity and adverse action. An adverse action is defined as any action that would deter an employee from filing a harassment or discrimination claim or participating in an investigation. Some examples that have been seen in court rulings and decisions from the EEOC are employment termination, layoffs, negative performance reviews, job transfer, loss in pay, benefits or overtime, less desirable job assignments, bullying, demotions, and unwarranted discipline, to name a few. Retaliation represents around 1/3 of all charges filed with the EEOC, the highest percentage of any type of claim. Retaliation can take many forms. Let's take a look at some real-life retaliation claims that violated California and federal law. A California security firm was sued by the EEOC on behalf of an East Indian man who was harassed for both his heritage and his age. After complaining, the man was involuntarily transferred, which resulted in a loss of hours and benefits. Not only was his complaint not investigated, he was retaliated against for filing it. Both the transfer on its own merit and the loss in hours and benefits are considered retaliation. In another instance, a man of Middle Eastern descent was harassed for his religion and heritage at a major U.S. company with locations in California. As a result of filing a harassment claim, he was transferred and forced to endure extreme micromanagement in his new position. Involuntary transfer is not a solution to a harassment complaint and is always considered retaliation. It will put managers and their organizations in legal jeopardy. A Hispanic bakery worker in California was subjected to ethnic and racial slurs by her boss. When she complained, her employer attempted to lay her off. When she refused, her employment was terminated. The EEOC sued her employer on her behalf. Terminating or laying off an employee for filing a harassment claim is considered illegal retaliation. In 2009, a male California movie theater employee was sexually harassed by a female coworker who repeatedly grabbed him inappropriately. He reported the harassment to his supervisors, who in turn reported the harassment to the theater's general manager. As a result, the manager retaliated by giving unwarranted discipline, unfairly lower performance evaluations, and/or stricter scrutiny of performance to the male employee and both of his supervisors. It is illegal to retaliate against an employee, a witness, a supervisor, or anyone else who files a complaint or who participates in an investigation. In this case, unwarranted discipline, unfairly lower performance evaluations, and/or stricter scrutiny were all considered illegal retaliation. The employer was fined $175,000 by the EEOC, and significant remedial relief was ordered.
Workplace bullying of any type is unacceptable in California. 50% of employees have either witnessed or been a victim of bullying in the workplace. Bullying has a profound impact on workplace productivity and employee morale. Psychologists have compared the effect of being bullied as similar to post-traumatic stress disorder. It destroys creativity, increases employee turnover, and spreads like wildfire through organizations, destroying them from within. What is workplace bullying? Amendment SB1343 mandates that training on abusive conduct be included with required harassment training. The law defines abusive conduct as the conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. Bullies use this malicious conduct to embarrass and humiliate coworkers and to expand their power and influence. Bullying can occur peer-to-peer, or it can be perpetrated by managers or supervisors who take advantage of their positions of power. Bullying can be physical, verbal, nonverbal, or psychological. It can occur face-to-face, on the phone or online, and be perpetrated by groups of employees or by individuals. Engaging in a pattern of one or more of the following behaviors meets the definition of abusive conduct under California law. The use of inappropriate language, put-downs, insults, and name-calling. Taunting, teasing, or making jokes about a coworker when the intent is to embarrass and humiliate. Sabotaging another employee's work, or copying, plagiarizing, or stealing work from a coworker and passing it off as your own. Deliberately isolating or excluding a coworker from work-related activities. Yelling, screaming, sarcasm, or other verbal abuse with the intent to threaten, intimidate, or humiliate. Menacing a coworker with threatening looks, gestures, and body language. Hazing or initiations that seek to physically or psychologically embarrass or humiliate a new coworker. Unreasonably creating conflict or refusing to work with a coworker. Physically threatening, shoving, striking, or touching a coworker in an intimidating or inappropriate manner. Gossiping or spreading rumors about coworkers, including the planting of false information or using private or confidential information to defame or destroy the reputation of a coworker. setting unrealistic standards and deadlines which are unachievable or that are arbitrarily changed without notice or reason, giving excessive, unreasonable, and unending amounts of work to a subordinate employee, deliberately denying coworkers the resources necessary to do their jobs effectively, ignoring, ridiculing, or belittling the contributions of coworkers or deliberately failing to acknowledge their good work, giving unjustly negative performance appraisals or taking unwarranted disciplinary action, singling out or treating a coworker differently or holding a subordinate employee to different standards than his or her peers, excessive, unneeded, and negative micromanagement. Workplace bullying has consequences. Because of the devastating impact that bullying has on a company's creativity, productivity, and morale, there can be severe consequences for engaging in it. It can result in disciplinary actions, including written warnings, suspension, demotion, and even termination. In addition, retaliation for a bullying complaint is strictly prohibited and could result in disciplinary actions up to and including termination. How can you stop workplace bullying? It's simple. Treat coworkers with respect. Treat coworkers fairly and equally. Speak up when you witness bullying. Any witness or victim of workplace bullying should report the abusive conduct to management or human resources. The best way to ensure that you don't engage in abusive conduct is to remember the golden rule. Treat coworkers exactly like you would like to be treated, with dignity, respect, fairness, and equality. After all, everyone deserves a workplace free of fear and full of respect.
In California, the Fair Employment and Housing Act prohibits harassment and discrimination because of gender identity, gender expression, transitioning, or sexual orientation. Gender expression is a person's gender-related appearance or behavior. Gender expression may be stereotypically male or female, a combination of both, or may not conform to any gender. Gender identity is a person's internal understanding of their gender, which may be male, female, a combination of male and female, neither male nor female, a gender different from the person's sex assigned at birth, or transgender. Transgender refers to persons whose gender identity differs from their sex assigned at birth. A transgender person may or may not have a gender expression that's different from the social expectations of the sex they were assigned at birth. Transitioning is the process in which an individual begins living as the gender by which they identify. The law protects employees who are transitioning, have transitioned, or are perceived to be transitioning to a gender other than the one assigned at birth. Sexual orientation is heterosexuality, homosexuality, or bisexuality. The following supervisor conduct is illegal under California law. Engaging in harassment or discrimination that affects tangible employment actions such as hiring, firing, demotion, or promotion. For example, refusing to promote a woman for no other reason than the fact that she does not dress stereotypically female, or terminating the employment of a worker who is undergoing or planning sex reassignment surgery. Requiring employees to tolerate harassment as a condition of employment. For example, a warehouse manager telling his employees that they will simply have to ignore homophobic slurs from their coworkers because they are commonplace in blue-collar jobs. Harassing or discriminating against employees because of a perception which is not true. For instance, a manager choosing not to give a job assignment to a woman because he thought she was a lesbian. Her sexual orientation is irrelevant in this scenario. She's protected either way. Making employment decisions or comments based on sex stereotypes. For example, refusing to hire job candidates whose gender identity is female for a job that requires heavy lifting solely because of gender stereotypes. Hostile environment harassment occurs when the conduct unreasonably interferes with an individual's work performance or creates an intimidating, hostile, or offensive working environment. Supervisors have the dual responsibility of avoiding harassing behavior themselves while watching for it in the employees they manage. The harasser and victim can be coworkers, but harassment can also occur between employees and non-employees, such as contractors, consultants, delivery persons, vendors, or even customers. Harassment can occur anywhere that employees represent their organization, such as work celebrations, dining with clients, conferences, trade shows, sales calls, and charity events. Harassment can occur in person, on the phone, through text messages, instant messages, emails, or through social networking sites. Hostile environment harassment can affect anyone in the workplace, even employees who were not directly harassed but were bystanders to illegal conduct could be victims. Using demeaning or offensive names or the use of slurs or epithets. Telling insensitive jokes that are demeaning or degrading. Using a customer's gender preference as a factor when assigning job duties to employees. Making derogatory comments about the traits or legal rights of a protected group, such as a man should not be wearing a dress. Excluding or isolating coworkers from work-related activities and assignments. For example, assigning a transgender person exclusively to job assignments that do not involve customer interaction when coworkers in the same position work with customers on a regular basis. Viewing offensive websites or using social networking sites to harass coworkers. For instance, making disparaging comments about gender expression on a coworker's social media pages or viewing anti-gay websites in full view of coworkers. Employees must be allowed to use restroom or locker room facilities that correspond to their gender identity or gender expression irrespective of their assigned sex at birth. Employers must provide methods such as lockable toilet stalls, individual schedules for showers, shower curtains, or any other appropriate systems to ensure privacy for employees in their facilities. Employers must designate single-occupancy restrooms with gender-neutral signage such as unisex or simply restroom. Employers must allow employees to groom and dress according to their gender identity. If an employer assigns gender-specific uniforms, employees must be allowed to wear the uniform corresponding to their gender identity. When employers have dress codes or grooming standards, transgender or gender non-conforming employees must not be held to different standards than other employees. Employees must be allowed to participate in employer-sponsored activities corresponding to their gender identity, including sports teams, team-building exercises, and volunteering. Employees in California have the right to be identified by the name of their choice and with pronouns that reflect their gender identity. Employers must ensure that all employees follow this preference or face liability in court. Refusal to address coworkers with their preferred name and pronoun is considered illegal harassment and subject to disciplinary action. Employers may use legal names and genders on government documents when obligated by law. Employees must be permitted to perform jobs or duties that correspond to their gender identity or gender expression, irrespective of the employee's assigned sex at birth. However, employers must work to limit the number of jobs where a person's sex is the determining factor for employment. Employers may not require any proof of transitioning or gender identity before granting employee rights guaranteed by law. Employers may only communicate with employees about their gender identity, gender expression, or transitioning if the employee initiates the conversation to discuss gender-related working conditions. However, employers may make a confidential inquiry of an employee for the sole purpose of ensuring access to comparable, safe, and adequate multi-user facilities. The law prohibits employers from asking about or requiring documentation as proof of an individual's sex, gender, gender identity, or gender expression as a condition of employment. Additionally, discrimination against an applicant who fails or declines to mark male or female on an application form is expressly prohibited. Employees have the right to report harassment or discrimination to the Department of Fair Employment and Housing for up to 1 year from the first instance of misconduct. The DFEH will investigate the complaint and help with a settlement or provide legal assistance if necessary. Also, victims may seek help privately through civil court and do not lose that right by filing a complaint with the DFEH. Victims of harassment or discrimination have the right to receive compensatory and punitive damages. Independent contractors are entitled to the same harassment and discrimination rights as employees. Employers are required to display a poster developed by the DFEH regarding transgender rights in a prominent and accessible location in the workplace. Retaliating against a coworker for filing a harassment complaint is illegal under California and federal law. Examples of retaliation include layoffs, negative performance reviews, job transfer, loss in pay, benefits or overtime, less desirable job assignments, bullying, demotions, and unwarranted discipline, to name just a few. Employers and their supervisors must take reasonable steps to prevent harassment from occurring. Supervisors who fail to prevent harassment or who engage in harassment themselves can be found personally liable in court for large monetary judgments and face disciplinary action up to and including termination. In California, harassment and discrimination on the basis of gender identity, gender expression, transitioning, or sexual orientation are strictly prohibited. It's critical that all supervisors understand what constitutes harassment and discrimination and ensure that the employees they manage understand as well.